Thank you. Please be seated. And welcome. One case will be heard this morning. That case is Mormann versus the Iowa Workforce Development. Ms. Bullock, you may proceed.
May it please the court, counsel. My name is Laura Bullock. I am here on behalf of Mr. Mormann. This case is before the court on an interlocutory appeal from a motion to dismiss. As noted in the briefing, a portion of Mr. Mormann's claims did survive the motion to dismiss and as such will not be discussed here today. The two issues that are before the court today are whether or not the Civil Rights Commission had the authority to enact Administrative Rule 161 3-3.3, and more specifically, whether the facts of Mr. Mormann's case require equitable tolling and equitable estoppel to apply, extending the 300-day time period found in Chapter 216. As an initial point with the court, Iowa Workforce Development and Mr. Mormann do not agree on the standard of review this court should apply to this matter. This court has held, and other courts have recognized, that jurisdictional requirements are about the power of a district court to hear a specific type of class. What we are here on today is the authority of the district court to hear this specific case. As such, Mormann asserts that the correct motion or the correct standard to apply is an error at law, and that all facts are taken as true as pled in the pleading, and all reasonable inferences from those facts are given.
Ms. Bullock, can we, in reviewing the ruling below, can we take into account, can we consider the text of the letter that Mr. Godfrey sent? It's the March 7th, 2014 letter, and also the deposition testimony by Ms. Wallert.
Your Honor, I believe at this point both parties have waived any argument that those can't be considered. However, I don't think it's necessary for Mr. Mormann to be successful in this appeal. Both of the summation of the letter and what Ms. Wallert said in her testimony are in the petition and on its face. And so the petition is enough. And while we are here on a motion to dismiss, it is an authority issue, and additional evidence was introduced at the district court level by both parties. And I do believe that's properly before the court right now. However, what doesn't apply is the jurisdictional standard of review requiring substantial evidence to be met to keep the claim alive. Moving to the Administrative Rule 161 3.3, this is the rule that it was enacted first in 1974 and allows for equitable tolling, equitable estoppel, and waiver to apply to the 300.
Do we have to decide whether or not the commission had the authority to even enter that rule? And if the commission did not have authority to enter that rule, do we have to then look at the statute and construe or interpret the statute to see if it does allow for equitable tolling?
You do not have to decide whether or not they have the authority. As argued in our brief, this court has held numerous times that the Iowa Civil Rights Act provides at least as much protection as the federal law that compares. Title VII, in this case the ADEA, because this is an age discrimination case. Both of those federal protections allow for tolling, equitable estoppel, and waiver recognized under common law.
But what authority did the commission have to even enter this rule?
In Iowa Code 216.5, the Iowa Civil Rights Commission is granted the power to adopt, publish, amend, and rescind regulations consistent with and necessary for the enforcement of the chapter. Iowa Code 216.15 also states that the commission shall establish rules to govern, expedite, and effectuate the procedures established by this chapter.
But what gives them, maybe my question was bad and I apologize. What is the authority for them to say that the legislature authorized tolling of the statute and just throw that in there. I mean,
Federal courts and this court have found that tolling of a statute of limitations as recognized under common law is a procedural requirement. So this isn't a substantive change to the 300-day limit in Chapter 216. It is a recognition of something that already existed, and the commission and then the legislature in enacting them.
so to decide this case, we really have to decide whether or not the legislature allowed tolling when it enacted the statute.
I believe that you can look at whether or not this court recognized and other courts around the country recognized tolling at the time the Iowa Civil Rights was enacted, and they did. This is something that applies to, I was hard pressed to find a civil cause of action that doesn't have, and has a statute of limitations that doesn't recognize tolling or discovery rule or equitable estoppel or waiver. Waiver,
Our
statute.
State Tort Claim Act and Municipal Tort Claim Act don't have discovery or tolling.
That is one. However, there's also other procedural rules that apply there. In any of the Civil Rights Act, in any of personal injury, medical malpractice, those all recognize waiver. Statute of limitations is an affirmative defense that one has to plead in order to be able to raise it. The 300 days is a statute of limit. This court has said is treated like a statute of limitations.
Let's cut to the merits quickly, if you don't mind. I mean, why wasn't your client on inquiry notice? He didn't get the job. How old was your client, by the way, at the time?
He was in his 60s.
Okay, so he's in his 60s. And how old was the person who got the job?
I believe she was in her 30s.
Okay. Wow, isn't it obvious that there was a potential claim? Practitioners sometimes have a 55-10 rule. If you're over 55 and the person that was hired was 10 years younger, you're on inquiry notice. So your client had extensive experience, was 63, was not hired, somebody in the 30s was hired. Doesn't that put you on notice that there might be age discrimination?
That hypothetical requires employees to assume the worst of their employers, which is not something that as a public policy we want employers or employees doing. That would mean every time someone who was a member of a protected class, a 60-year-old individual, had an adverse employment action, they should automatically rush to the commission and file a complaint. What happened here?
Well, not quite. I mean, what it says is if you're 63 years old, are highly qualified for the position, and in fact have served in the position in the past, and then someone is hired who is in her 30s, that is enough to say, ooh, I better look at this. I mean, doesn't that, as a lawyer, if you're confronted with those facts, don't you say, ooh, age discrimination, this is, I mean, isn't it just kind of crying out to you?
I do, but I practice in this area, and this isn't a reasonable lawyer standard. My client happens to be an attorney, but this is the standard for tolling and estoppel is a reasonably prudent individual. Mr. Mormann did try and take steps to determine why he wasn't selected for the position. Looking at the letter, which is on page 13, the letter is just in the record as indicated, and looking at the civil rights complaint, which is on pages 13 and 14 of the appendix. The letter, which IWD tries to argue is a pro forma letter, is personalized. It's clear that Chris Godfrey and Mr. Mormann spoke prior to the letter being sent. He says in the letter, as I mentioned before, you were a finalist. My client tried to reach out and discover reasons that he was not selected. Ms. Whalert took steps, as pled in paragraph 23, to hide the true reasons that he was not even considered for the position. And it's in those unique set of circumstances that tolling should apply. It's not notice if he went to his employer, he tried to inquire, why was I not selected for the position? And he was told, you were a finalist, and we encourage you to apply again. giving him the impression that in the future he would be considered for the position. However, what came out in the deposition is that he was never going to be considered for this position because Ms. Whaler believed that he was too close to the age of retirement.
Was there anything said during the interview process that gave her to support that statement that he would be retiring relatively soon?
She does assert that in the deposition. However, that's not in our petition. We are again on a motion to dismiss, and those facts have not yet been discovered. It is exactly the reason this case should be allowed to proceed through discovery. And I see my time is running out. May I finish?
You may.
Allowed to proceed to discovery. This issue could be more properly dealt with at the summary judgment stage, when the parties have had the opportunity to flesh out the facts relating to whether or not, he made statements in the interview and how much my client truly knew at the time that he did not receive the promotion. The facts as pled are sufficient to survive a motion to dismiss, and the state of Iowa requires notice pleading. As such, this court should reverse the holding of the district court and remand the case for further proceedings.
Ms. Bullock, thank you. Mr. Faith.
Good morning, Your Honors. May it please the court. My name is David Faith, representing the state of Iowa. As all parties have conceded here, the Iowa Civil Rights Act requires that a claim be filed with the Civil Rights Commission within 300 days. And as all parties also concede, that hasn't happened. So the only way this case can go forward is if you conclude both that there are one or more equitable exceptions and that the facts of this case justify invoking those exceptions. Now, there's a threshold issue of whether or not the Civil Rights Commission can even create equitable exceptions, and thereby, in effect, through agency rulemaking, expand the jurisdiction or authority of the state courts.
Let's get to that. Does the statute allow equitable tolling?
The statute does not.
And why wouldn't we apply the common law principles we apply to every other statute of limitations?
Well, the legislature could well have included that. They did not.
It's not under 614.1 anywhere. And we've said that the discovery rule applies.
Well, there's no precedent for applying it to a civil rights claim.
Well, but at the time the Civil Rights Act was passed, in 1965, there was a bushel basket of case law where we, the Supreme Court, found a discovery rule with respect to statute of limitations. Why wouldn't the legislature have assumed that the ordinary approach of the cases prior to 1965 applied here too?
Well, this is somewhat of a special case because here the legislature was creating an agency charged with investigating these matters. The Civil Rights Commission has powers that an ordinary litigant doesn't. It can compel discovery, have hearings, bring witnesses. It has a toolbox to get.
The court has all those powers, of course.
The court has all this power too. But what I'm getting at is the legislature created a mechanism for someone to have their claim investigated, and because of that, they put a reasonable time limit on invoking the right to do that. But the truth of the matter is, Your Honor, even if you're inclined to create an equitable exception, this is a bad test case for it because the facts before you don't support an equitable exception. Even if
but we have to take all the well-pleaded facts as being true for a motion to dismiss. And what facts that are contained in the well-pleaded facts lead a reasonable person to believe that this gentleman was on inquiry notice?
Well, respectfully, Your Honor, under the authority of Tiggs versus City of Ames, when a court is confronted with a matter with a question of its own authority to proceed, it should take charge of the proceedings affirmatively, regardless of the vehicle used to raise the issue, utilize the most efficient methods at its disposal to determine the true fact, and decide the issue.
So you want to turn this into a motion for summary judgment?
Well, I don't want to, but if you believe that's necessary, the Tiggs course also held, I'll quote, "We have indicated that form must give way to substance and treated a motion to dismiss as a motion for summary judgment." The point here, Your Honor, is that once the authority of the court is in question, then reasons of justice and
Okay, let's do it whichever way you want to do it. I'm not going to quibble with you about that. Tell me what facts in this record show that this gentleman was on inquiry notice.
sure, he knew no later than March 2014 when he got the rejection letter, and as he's admitted in his own filings that he was a member of the protected group, that someone from outside the protected group got the job, that he was qualified for the job, certainly asserted that, and that a person 20, 30 years younger than him with no prior experience in the role got a job that he previously done twice before. So he knew all of the elements of a prima facie case no later than March.
So every time they hire somebody younger than you, then you're qualified for a job, you need to run down to the Civil Rights Commission and file a complaint. Is that the position the state's taking?
Under circumstances similar to this, it certainly is, Your Honor. And I think if you look at this court's decisions in Landals versus George A. Rolfe's company and Christie versus Wall Street, both of them involved a younger person getting a job over an older person. And the court held that that created an inference of discrimination. Because the important thing here is that for inquiry notice, we're just talking about aware of a possible thing. Obviously, you don't have to be certain of your claim, but it starts the process for investigating your claim. And Iowa gives you this great Civil Rights Commission process as a means to investigate your claim. That's why you bring it there. And that didn't happen in this case. Now, if I could, I'd like to jump briefly. We talked a little bit about the equitable tolling. I'd like to jump to the equitable estoppel issue. And that's distinct from tolling in that there we're talking about the defendant having engaged in wrongdoing, having fraudulently done something to conceal the existence of a claim.
And doesn't that require discovery?
Not when the relevant facts are already in the record. The letter, as the plaintiff's counsel conceded, can be considered by the court, and that's primarily what they're claiming is the thing that fooled him into believing he didn't have a claim.
Well, I know, but wouldn't if you want to develop an equitable estoppel argument, wouldn't you want to take Ms. Waller's deposition and maybe Godfrey's deposition and confront Ms. Waller with her prior testimony? He says, well, he said he was close to retirement. What do you mean by that? I mean, how many times did you say that? Who'd you tell that to? Did you ever say he was too old? Do you think he's too old? Yeah, I mean, do that kind of inquiry. And the same with Godfrey. Say, here's this letter. Did you draft the letter? Did somebody draft it for you? Did you believe it? Did you not? That kind of thing. Unlike inquiry notice, where I think we do have kind of a closed universe, here, are we ready to say now, as a matter of law, which you asked us to, that we're going to shut off that inquiry entirely?
Well, Your Honor, certainly you can always find additional information, and there might also be additional information out there that would be helpful. But the question is, based on the record before you now, is there enough to support Judge Stayskull's decision?
Yeah, you're trying to turn that into a motion for summary judgment again, I think, maybe.
Well, again, because this has never been a motion to dismiss for failure to state a claim. From my very first pleading, first paragraph, I said this is a motion to dismiss for lack of jurisdiction and authority.
I mean, if the basis for the equitable estoppel is the letter, can't we just look at the letter and decide if under any set of facts that letter could serve as an equitable estoppel?
Your Honor, you can certainly look at the letter. As for whether any other facts, I think you should certainly consider the other facts that are before you for context.
I'm trying to ask a friendly question, actually.
Okay.
You have your guard up. It seems to me that if it's a motion to dismiss, if you're wrong about the standard of review, and this is a motion to dismiss and it's subject to the normal, is there any set of facts in support of the claim that the plaintiff could present? Well, if the plaintiff's basis for equitable estoppel is this letter, and everyone agrees it's this letter, and we look at this letter, and we decide as a matter of law that it can't be an equitable estoppel, then you win on that point, isn't that right?
Yes, Your Honor, because there is no set of facts in which this 5-sentence rejection letter, which contained nothing but true statements.
Well, how do we know it's true statements?
Well, Your Honor, let's go through it. I'm writing to regretfully inform you that we've decided an alternative candidate to fill the position of Deputy Workers' Compensation Commissioner. By the facts, that's
true. Keep going.
Everyone
Yeah.
agrees to that. The decision was a difficult decision, as I mentioned before. You were one of the finalists.
Well, he says, as I mentioned before, so it sounds like there was some kind of oral discussion that we don't know is in the letter.
And maybe he got an order to not hire the guy because he's too old.
Well, there's no record, there's no evidence in the record to support that, and the evidence that does exist, the deposition transcript, is that the hiring committee picked Aaron Powles as their first place candidate, came to Teresa Whaler with that and said, this is our first place candidate, Mormann is our second, and she said, I'm fine with your first place candidate, I might have some concerns with your second, but her concerns were never even spoken because Ms. Powles accepted the job. So actually, based on that evidence, it suggests that any concerns she may have had secretly in her own mind were never even voiced to Godfrey or the hiring committee. Finally, I want to note something that I think needs clarification. That the transcript's deposition wasn't released because there was a protective order in the case, as even plaintiff acknowledges on page 7, where they say there was no way for Mormann to discover the contents of these depositions because they were under district court gag order. I see I'm out of time, Your Honor. Can I just finish my thought?
You may.
So any concealment, quote unquote, there was the result of following a lawful court order, which is certainly not inequitable and would certainly not justify equitable stop. For all the reasons, I urge you to uphold Judge Stace's ruling.
Mr. Face, thank you.
Thank you.
Ms. Bullock, rebuttal?
What is it about this letter that causes you such grief? Godfrey writes, says, we all know what its contents are, I guess. It's a relatively short letter. There's no evidence that Godfrey didn't think exactly what he said was true. And there's some evidence, I guess, that what he said in the letter was true. Address the question, how does this letter of Godfrey give rise to a claim that there's shenanigans afoot in this government agency?
The letter is only part of the evidence for the motion to dismiss, Your Honor. In paragraph 22, we specifically pled that Waller placed a gag order over everyone involved in the hiring process. That's distinct and separate from the protective order that existed in the
But that doesn't go to the estoppel. That might go to your tolling. We're talking now about the estoppel piece. That's just based on the letter, isn't it?
No, Your Honor. The estoppel is based on both the pleading and the letter. But the estoppel, one of the elements for the estoppel is concealment. And Director Waller took steps to conceal from Mr. Mormann the true reasons that he was not selected for the position. That concealment included, one, playing a much bigger role in the hiring process than she had previously, which is in Mr. Mormann's sworn statement to the Iowa Civil Rights Commission, pages 13 and 14 in the appendix, that she had not played a part in the decision prior to this. She inserted herself in this decision, and then she instructed individuals involved in the hiring decision not to talk about any part of the process.
But is there any evidence that the committee recommended Pals? I think Pals is her name. The committee recommended Pals, and Pals was hired. So how do you get even Miss Waller intervening in there and saying, I didn't hire Mormon because of age?
We have Ms. Waller's deposition testimony on that, and what IWD is attempting to do is arguing that her testimony supports the fact that there's no concealment. That is not been subject.
She didn't make the decision. They hired the person who the committee thought should be hired, and Mormon wasn't that person.
She said she did not make the decision in her testimony. We have no idea what Chris Godfrey would say about who actually made that decision, which is why this is not the proper.
Well, haven't you talked to Mr. Godfrey, either on or off the record?
We have, Your Honor, and we have fought that fight and lost as to get that evidence before the court here. So I can't talk about what Mr. Godfrey has or has not said, unfortunately. But what IWD can't do is use facts, the deposition testimony, to support its assertion that there was no concealment when we have not had the opportunity to cross-examine Ms. Bullock. We have not had the opportunity to establish whether or not those statements are in fact accurate. The letter itself, IWU also tries to argue, is both not significant enough to trigger equitable tolling and significant enough to tell Mr. Mormann that he should have filed a claim.
What was it about the deposition that, made this all come together for him, the Rosetta Stone of the case?
Mr. Mormann wasn't selected for the position, as the civil rights complaint states and as found in his petition. He tried to find out why he wasn't selected, and the letter supports that. There was a conversation that happened. When he was given what he thought was a legitimate reason, he didn't jump to the worst conclusion. He knew that he needed to have some evidence, some merit to a claim before he filed.
Is inquiry notice about being handed to you on a Rosetta Stone, or wasn't there enough early on?
There was not enough because there was concealment here, and there was the misrepresentation that he would be considered for open positions in the future. The deposition testimony makes it very clear he was never going to be considered for an open position. She thought he was too close to retirement age, and she was not going to allow him to be considered.
But that's not what the deposition says. The deposition says the statements that Mr. Mormann had made to people during his interview that he thought he was going to retire.
It goes on to say that then a discussion would have to be made about whether or not that was going to be a good financial decision.
Is it illegal for an employer to consider how long somebody who's seeking a position, how long they'll stay in it? If it involves a learning curve and training, can't they legitimately favor a candidate who will be in a job longer?
My time's running.
You may.
It's not illegal to consider that, but we have no idea, even if Mr. Mormann was talking about retirement, was he talking about retirement in 3 years, 5 years, 10 years? We don't know what that time frame was. It is not irrational to start planning for retirement when you're 40 and talking about when you might retire. We don't know what those statements were because we haven't been able to develop the factual record.
You may sum up.
Thank you, Your Honor. The purpose of the Iowa Civil Rights Act is to discourage and eradicate discrimination. There has to be a mechanism to hold employers accountable in very unique situations like this, where after the 300 days has elapsed, it is discovered the true reason for not hiring was discriminatory. That is all we're asking for in this case. The facts as pled are sufficient to survive a motion to dismiss, and this court should overturn the district court. Thank you.
Ms. Bullock, thank you as well. The case of Mormann versus the Iowa Workforce Development is now therefore submitted to the court.